All of you, sometime in your career, will either be a trustee, especially those of you who are just getting started in your career, advising a trustee, such as an investment advisor, or advising clients on trust. And therefore, we want to spend a little time going over what are the duties and tasks of a trustee. Our objectives, after completing this module, will be able to describe the commencement of the trustee's responsibility to the trust, list the basic duties of all trustees, describe how to determine which state law applies, discuss the checklist applicable for a testimonial trust, and discuss the checklist for an inter vivos trust. And this is probably the best way of saying a trustee. They are a butler. They do what they're supposed to do, for the rules they're supposed to do, and they don't deviate. And there's not a lot of flexibility. When does duties take effect? Well, if we have a inter vivos trust, then it takes effect when we sign the trust agreement by the trustee. If it's a testamentary trust takes place when the court assigns the trustee as the trustee for it, and that's on the pour-over will. And this makes, at that time forward, the trustee assumes all responsibilities of the trustee, which we'll be discussing. Specific list of duties. You can't list all the possible duties that might come up, and we'll cover the most common during the rest of this module. The following duties are from the Restatement of Law, Third Restatement Trust, which is relied upon by all the courts and is a good guideline for any time of trustee. Now, if you are administering assets in the trust, such as you're an investment advisor supporting a trustee, or a trustee who's doing investment advice, you also have the prudent investment rule. But we're assuming, for purpose of this session, that we're not involved with the assets of the trust. We're just what you do as a trustee in general. And the first one is duty to exercise reasonable care, skill, and caution. Now, I mentioned earlier in my discussions that we're talking about the duties. And one duty you cannot get out of is the duty of exercising reasonable care, skill, and caution. Almost any other duty you can think of can be modified or changed by the grantor setting up the trust. But this is an exception. You cannot get out of these. So you might as well learn it and make sure your clients understand it. First, we have a duty to exercise such care and skill as a man of ordinary prudence would exercise in dealing with his own property. In other words, you have to say, what would we expect a person to do with their own property? That's what we would expect as a minimum for the trustee. And if you fail to do that, in the eyes of the court, you're going to be held liable. And again, the burden of proof is on you, so the trustee must document it. And again, if you have clients, be sure they understand the key importance of documentation. If a trustee represents that he has greater skill than a man of ordinary prudence, he is under duty to exercise such skills. So if you hold yourself out as an investment advisor, is more responsibility than if you hold yourself out as a professional fiduciary. Note that the liability, even if acted in good faith and used all the care and skill he were capable of, well, we set up a higher standard that you have to live with. Care, inquire, examine, investigate before taking action, due diligence and attentiveness to the matters of the trust. Bottom line, do your homework and document your homework. Skills must have the necessary ability to handle the trust or obtain it elsewhere. Again, you were picked, or your client was picked as trustee because of what you did in the past and your alleged skills that you've advertised, maybe on your business card. Calling yourself a general financial planner probably makes people think you're an expert on trustees as a trustee. Therefore, you have to face that would be a higher standard on you than, say, someone who is just a layman. Preserve trust assets and avoid speculation and recklessness. Now, we'll get more into preserving trust assets when we talk about prudent investment rule. But for purpose of any trustee, you have to, our obligation to protect the trust assets and avoid speculation and recklessness. That is a baseline. Duty not to delegate. The basic rule of trusting is you don't delegate to others the performance of acts that the trustee can reasonably be required to perform personally. Now, the rules vary from state to state, how rigid that is. For example, I've seen where a person was assigned as a trustee, they had a deficiency in some skill, and they hired someone to do it for them, like budgeting would be one thing, or investment advice, or being a manager of apartment house. They had hired experts. But as a general rule, you're expected to be able to do what's called out in the trust if you're a trustee. Fiduciary role is a personal one, which is quite obviously, that's the main reason we got all of these rules on trustees, because they are fiduciaries. You must delegate activities that require professional skills or facilities that the trustee does not possess. So if you extend yourself beyond your capabilities, you're in trouble. That's what that sentence is saying. And therefore, if you're not an expert in investment advice, don't try to do it. Let's say you're a tax preparer and you've been asked to serve as a trustee by their client for some financial matters, and you don't have the financial background, don't do it. Likewise, if you're an investment advisor, don't try doing the income tax for the trust. And finally, it says some states are more flexible than others on the delegation. You really have to look how it's being interpreted in your state. Your local bar association can tell you about it, or maybe if you belong to a state planning council, which many financial planners do, they can tell you how strict the state is. Duty to keep and render accounts. You must maintain a book account that shows in detail the nature and amount of the trust property, the income it produces, and all activity relating to that property from the trust inception to its termination. It's a lot broader than you probably think. And it says this duty, although for the benefit of the beneficiaries, is also protection for the trustee. This is part of that documentation that's so important for trustees to have, to document everything they do. And that books of accounts is certainly one of them, which we'll get to later. Duty to take and keep control. Use of custodians and other agents is allowed and sometimes may be the only prudent course. For example, if you have real estate that you're managing under the trust that's found in 4 different states, quite honestly, we cannot expect the trustee to manage all 4 sites. So they have to get rental property managers. That's obviously the thing to do. If we use a custodian or other agent, trustee must act prudently selecting him or her, arranging the duties and authority, and continuously monitoring. Well, first of all, that means you don't pick your brother-in-law to do it. You figure out the best person who can do this job for you, that understands the responsibility of acting under a trust. We also want to make sure we put in writing the duties and responsibilities of the individual, and we want to monitor them. The monitoring includes documentation of the monitoring. And examples that they typically give in courses are the bank and brokerage accounts. My example is usually the real estate in 4 different states because that's so obvious. But you have the same responsibility if you use a bank for storage of money or brokerage accounts for your securities. You got to go through all the steps in picking it, arranging the duties, and the monitoring. So you just don't pick Bank of America because it's the closest bank. That's not the answer. Why would you pick them? And what type of conditions did you put in writing to them? And then finally, how are you monitoring them in writing? Duty to preserve the trust property. Must use reasonable care and skill to preserve the trust property. This means protecting it from damage or loss of value, which may require insurance against theft, fire, etc., safekeeping your securities and keeping tangible assets in good repair. I knew one trustee who had stocks that the owner in his trust said, we don't want these sold, we want to retain these. And so he said, well, the easiest way for it is I'll put it in my own safe. So he put it in a safe he had in his office, but the safe was a low level that anybody could get into, even me, so that was not a good decision because The securities did disappear. Probably it was done by his secretary, but he couldn't prove it. And it obviously wasn't safekeeping the securities. And if you have tangible assets such as houses or automobiles, you must do preventive maintenance and repairs. And most states use the prudent investment rule, which is on the next slide, for the investments involved. And it says, when the governing trust has been silent concerning the types of investments permitted, the fiduciary is required to invest trust assets as a prudent man would invest their own property with the following factors: the needs of the beneficiaries, the needs to preserve the estates or corpus of the trust, and the amount and regulatory of income. The application of these general principles depends on the amount of account administered and the type administered. So value and the type makes a big difference in what you're to do. The approach allows fiduciary to utilize modern portfolio theory to guide instrument decisions and requires risk versus return analysis. Therefore, a fiduciary's performance is measured on the performance of the entire portfolio rather than the individual investments. I think the most important thing here is we can use the modern portfolio theory, which is very important. It doesn't stick us back to where we stick everything in the U.S. savings bonds and real estate. And that's a big advantage of prudent investment rule. That rule is used in 48 of the 50 states, either in total or major part with modifications, when applying to the assets of a trust, the investment assets of a trust, obviously. Principles of the prudent investment rule. Essence of the new rule: there's no investment or technique that's imprudent per se. There's 5 basic principles that you should be aware of. Diversification, of course, I think everybody realizes risk and return are related, and the trustee has a duty to have the right risk for the purpose of the trust. Again, probably the most important thing there is documentation of it in the policy. Duty to avoid unjustified fees and other expenses, conscientious balance, current income versus growth, and duty and authority to delegate as prudent investors would. These are the 5 basic principles that a prudent investment advisor rule uses for assets that are investments in the estate, or in the trust rather. It also applies for an estate, same type of rules. Duty to enforce claims and defend actions. Successor trustees have a duty to obtain an account of predecessors' activities to ascertain whether any surcharge claims exist for possible past imprudent actions. When I first became a certified financial planner, I did 5 or 6 trusts for attorneys, and the first thing I did is go through every step that the previous person did, all their documentation or lack of documentation. And I think the thing that surprised me in the most part was how sloppy was the documentation and how incomplete it was. And they were just setting themselves up for problems. Fortunately, it was a very good time in the stock market. It was in the late 80s, before we had a downturn. Testamentary trust trustees have a duty to obtain an account of the executor's actions to ensure that the trust receives all the properties entitled to and to redress any breach of duty committed by the executor. Same thing. You have a responsibility not only for your actions, but for the actions before you, be you taking over a trust or taking over the actions from probate. And finally, a claim may resist regarding investment, such as a bond default or failure to collect and remit the dividends. One of the things I did is I went through the state of California, because I'm located in California, on the trustees' assets to see if there were any assets that were not covered that were excheated to the state. And there was a bank account he had with one of them was about $5,000. There was some other accounts that were smaller that I found on clients that were previous trustee did not catch, nor did the executor, and I got the money for the account, which wasn't something special. That's what I had to do. Duty to keep trust property separate. Let's keep trust property separate from trustees' individual property, separate from property not subject to trust, ensure property is designated as property of the trust. Bluntly, each trust has to have a separate account. You may have a $5 million account, a trust, and a $300,000 trust, and a $30,000 trust. All three are separate. All three must be designated as who the trust is. So it might be the John Smith Trust of 2014, the Mary Elder Trust of 2006, and the J.B. Watkins Trust of 2014. Each of those have to be separated. They need separate bank accounts, separate brokerage accounts, etc. No commingling, especially no commingling with your own money, because that is probably the only way I can think of a lawyer being disbarred in California. You got to really try to be disbarred, and commingling with client assets is the best way. Duty to make trust property productive, manage the property, produce a reasonable income for the property, and preserve the value of the corpus or remainder. Then leave large sums of cash uninvested. Violation of the duty. Even with the small amount of interest we're paying today, 0.5%, it still has to be invested. Trustee with unimproved real estate property must seek ways to make it productive income. If you drive along the freeways of California, Arizona, Utah, in the middle of nowhere, you're going to see signs advertising products. That's one way to make vacant land productive. We're going to cover the duties of the trustees. And trustees of living trust after death of the grantor. It's a guide. And these are the steps you use that are available to you on the PowerPoints. Collecting all estate planning and other important documents, transferring the deeds and titles to beneficiaries, review trusts for data regarding trustee powers and limitations therein. You do that before anything else. Then you create the inventory, meet with the attorney and tax advisor, establish the bank account, apply for insurance proceeds, employment compensation, government benefits, etc., and check annuities, retirement plans, life insurance, etc. I might note that it's not only good for trustees, but it's good for executors working with the attorneys to do these. Remember, the more you can do for the attorney, the less the attorney's going to have to charge you. Tasks typically done by family members or co-trustees. Again, this is not done by the courts, not done by the attorneys. This will be typically done, if it's a trust, by the trustee, if not by family members. First of all, notifying family and friends of the death, arranging for child and pet care if applicable, such as going to court and getting a guardianship, safeguarding valuables, such as putting locks on the buildings and maybe arranging for security guards, making the burial cremation decision, arranging the funeral, canceling utilities, submitting the obituary so that public notice is made for creditors, forwarding the mail, stopping newspapers and magazines and credit cards, arranging yard sale if necessary for miscellaneous items for the estate, and claiming Social Security benefits if eligible. Sample trustee checklist. Set up a system for bills, income, assets, and debts, which is basically basic accounting. And you have all sorts of software for that. Find all important documentation, be it wills, trust, birth certificates, divorces, ownerships of businesses, ownerships of bonds, etc. Send original pour-over will to the clerk within 30 days. Provide all beneficiaries of the trust that exist, and you are trustees within 60 days. So if it's a pour-over will, it's 30 days. If it's not a will, you have 60 days notice. Review and understand the trust terms. Send notification of those listed on the following slide. Obtain tax IDs for trust. Set up a separate bank account. Begin insurance. Benefit administration retirement plan proceeds as applicable. Get appraisals and smart trust and estate tax returns. Again, this is if it's not covered by will. If it's covered by probate, the probate does a lot of this stuff. I would say the one thing I would do, even if it was probate, is I would make sure that the bills, income, assets, and debts were all checked again. Again, it'll save a lot of money for the trust. For the will, probating. Notification is who is trustee. Now, so you're taking over as a trustee either for a pour-over trust or for a living trust, and you're the new trustee. Notify all beneficiaries of actions taken and update if it takes over a year to close the trust. And this is especially true for pour-over trust. Usually the things should be done within a year. If they're not, make sure you do give the notices. Make sure you notify the bank and brokerage houses that you're the trustee because you have legal title. The credit cards companies have to be notified. Again, legal title, pension insurance companies, social or membership organizations, Social Security Administration, and Medicare. Medical and Medicare could be include Medicare or Obamacare. Any known creditors and public notices for others. Notifying the accountants, the attorneys, the tax preparers, insurance agents, brokers, banks, etc. Summary. In this module, you learned the starting point for being a trustee of an inter-virus and testamentary trust, the duties of a trustee under the Uniform Trust Code, which is independent of the whether or not there's any investable assets in it, and the sample trustee checklist for inter-virus and testamentary trust.